What happened inside Judge Glenville's chambers on June 10th, 2024 would soon become one of the most talked about moments in the Fulton County Courthouse. Jeffrey Williams, better known to the world as Young Thug, was first indicted on May 9th, 2022 in Fulton County, Georgia, under the state's powerful anti-racketeering law. Later, on August 8, 2022, prosecutors filed a re-indictment, expanding on the original charges. Authorities accused Williams of being the leader of a street gang known as YSL, Young Slime Life, claiming that it operated under the guise of his record label, Young Stoner Life Records. The charges included conspiracy, participation in criminal street gang activity, and several weapons and drug offences. As the high-profile case moved toward trial, the courtroom saw a series of intense moments. On June 7, 2024, Fulton County Superior Court Chief Judge Uriel Glenville, who presided over the case, found one of the prosecution's key witnesses in contempt of court after the witness refused to testify. Even after being granted immunity, Judge Glenville ordered that the witness be held in jail until Monday, June 10th, 2024, when the court would revisit the issue and determine whether he was ready to take the stand. That Monday morning, something unusual happened. Judge Glenville met privately in his chambers with prosecutor Adrian Love, the witness, and the witness's attorney. The discussion was officially transcribed by a court reporter, and by the end of it, the witness agreed to testify. However, there was a major issue. The defense attorneys for Mr. Williams and his co-defendants were not informed of this meeting, nor were they present during it. That meant the meeting qualified as an ex parte communication, which is any discussion between a judge and one side of a case without the other side being included. According to Rule 2.9 of the Georgia Code of Judicial Conduct, judges are prohibited from allowing or initiating such communications in ongoing cases, except in very limited circumstances. When Brian Steele, one of Young Thug's defense attorneys, learned about this private meeting through an undisclosed source, he immediately raised the issue on the record in open court before Judge Glenville, sparking a new wave of controversy surrounding the already complex and closely watched YSL trial.
Go ahead. The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution and the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason...
Well, I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going to
did
answer
you?
that question.
You're not.
No, I will not answer that
Why
question.
will you not answer that question?
Because I want to make sure that what I say is accurate. And I'm not trying to
No.
get anybody else.
I'm asking you, how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have-
Somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
A
I would
party,
yes.
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me,
Copeland.
tell me how you
perjury.
got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going
Well-
to say is this. I was told, and I hope this concerns the court.
It
I was
concerns
told-
me that you have proprietary information.
Why is it
or
proprietary?
information that you should not be having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
No, that's-
this honorable court,
Okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who
I'm not-
tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then,
answering that question. But Mr. Copeland made statements that he admitted to killing.
The courtroom was tense when Judge Glenville turned to Mr. Steele and demanded to know how he'd learned about the secret ex parte meeting. Calm but firm, Mr. Steele refused to answer, citing attorney-client privilege. The judge didn't take that lightly. He immediately called for a 5-minute recess, warning that if Mr. Steele didn't reveal his source when they reconvened, he'd be held in contempt of court. Under Georgia's Rule 1.6 of professional conduct, attorneys must protect all information gained from their clients, regardless of how it was obtained. The rule's commentary makes it clear this duty extends beyond confidential communications to any information acquired in the professional relationship, yet there's one critical exception. An attorney may disclose such information if ordered by a court. When the break ended, Judge Glenville returned to the bench and called Mr. Steele forward.
okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy. But as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know
Lies.
what the rule says, but here's the thing.
Well, let me just- let me just tell you Interrupt.
you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's
That
why
is the
that's
issue.
why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not. I'm trying
The issue is how did you get this information?
I understand the issue. I promise you I understand it. But what I'm trying to ask you is if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get the information?
But just listen to what I'm trying to tell you.
You're saying,
you're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Once again, Mr. Steele stood his ground and refused to identify his source. True to his warning, Judge Glenville found him in contempt, giving him until 5 p.m. to comply. The judge reasoned that he wasn't asking for client secrets, only the method by which Mr. Steele learned about the private meeting. But to Mr. Steele, that distinction didn't matter. He believed that even sharing his source would break his ethical duty under Rule 1.6.
Well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not going to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge, listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can
okay,
talk
well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well, it's because she has a client she's supposed to represent.
Who are you talking
about? But anyways, I'm not going to have a...
When I got this information...
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in time.
I think that the court needs to again declare a mistrial based upon...
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based upon information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
why
that's for another day.
In the first place, I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
Okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence.
Mr. Steele then moved for a mistrial, arguing that Judge Glenville's ex parte communication with a witness made it impossible for the trial to continue fairly. A mistrial, by definition, ends a trial before a verdict when fairness can no longer be ensured. In such cases, a new trial may be granted unless barred by double jeopardy or another legal rule. His motion leaned on a precedent from the 2016 Georgia Supreme Court case of Scudder v. Georgia. In that case, the court reaffirmed that criminal defendants have the right to be present during every critical stage of their trial, unless that right is knowingly waived. In Scudder, the defendant's absence from a judge's private meeting with a witness wasn't deemed an error because the judge had announced the meeting in open court and neither the defendant nor his counsel objected. But this situation was different. Judge Glenville's meeting happened behind closed doors without informing the defense or giving them any opportunity to attend or waive their right. That secrecy gave Mr. Steele and the other defense attorneys strong grounds to argue that the defendant's rights had been violated.
You're not supposed to have communication with a witness who's been sworn. You know, that I'm not telling you, I'm just saying if you read I'm assuming you read it. That's what it says. And you did it supposedly.
Does the state wish to be heard?
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information, somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
well,
why aren't we entitled to the
that needs to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on the
Just stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1, paragraph
you've
12.
already said that. You've already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition. He asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen.
Prosecutor Ms. Love, however, pushed back. She maintained that the defence had no right to attend the meeting since it concerned a civil contempt matter involving the witness, separate from the criminal trial itself. In her view, Judge Glenville was within his authority to handle that issue privately, as the defendant's liberty wasn't at risk in that moment. Still, the defence argued that even if the meeting was technically about civil contempt, it directly affected the criminal case, because afterward, the witness agreed to testify for the state. As legal ethics dictate, judges are prohibited from private discussions on substantive matters in an active case. That made Mr. Steele's argument that the defendant's rights were compromised even stronger. When multiple defense motions for mistrial were denied, Judge Glenville turned his attention back to Mr. Steele.
Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No. It's not, sir. Sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only
okay. Well, then you've made your. No, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
The attorney once again refused to disclose his source, prompting the judge to hold him in criminal contempt and order deputies to take him into custody right there in court. Mr. Steele was briefly removed from the trial, but later that day, Judge Glenville allowed him to return, explaining that he didn't want to deprive the defendant, Mr. Williams, of his chosen lawyer. Instead, the judge sentenced Mr. Steele to 20 days in jail, to be served only on weekends, so he could continue representing his client during the week. In a surprising move, Mr. Steele requested to serve that sentence in the same facility as Mr. Williams, so they could keep preparing their case together. But before he could serve a single day, Mr. Steele appealed. The Georgia Supreme Court quickly stepped in, issuing an emergency stay that paused the sentence. Then, in October 2024, the court reversed the contempt order entirely, ruling that Judge Glenville should have recused himself from handling the matter, since he was personally involved in the dispute. Mr. Steele never served any time. A few months earlier, on July 15th, 2024, Judge Rachel Krause of Fulton County officially removed Judge Glenville from the case, following defense motions for recusal. Judge Paige Reese Whitaker was appointed to take over the trial. Then, on October 31st, 2024, Mr. Williams entered a plea deal, pleading guilty to 1 gang charge, 3 drug charges and 2 firearm charges, while entering a no contest plea to another gang count and a racketeering conspiracy charge. His sentence, 40 years, with most of it suspended. He received credit for time served on his initial 5-year term and was placed on 15 years of probation. Under his sentence, any violation of probation terms could land him back in prison for up to 20 years. This entire series of events highlights one of the oldest struggles in law, the delicate balance between judicial authority and attorney ethics. Judge Glenville believed he was acting within his power to maintain courtroom order, while Mr. Steele stood firm in his duty to protect client confidentiality under the Georgia rules of professional conduct. And beyond their personal conflict lies a greater issue: ex parte communications. Even when nothing improper happens, private meetings between a judge and one side of a case can damage public trust. The rules exist to prevent not only unfairness, but also the appearance of it, ensuring that every defendant has confidence in the impartiality of the system. At its core, this case is a powerful reminder that justice depends not only on what the law says, but also on how faithfully those within the system uphold its principles. Don't forget to like and subscribe for more contents like this. Also, let me know where you are watching from in the comments.